to an unknown and newly registered company. The name of the company? Malibu Oil and Gas Limited. Then 3 years after, on July the 2nd, 2001, President Olusegun Obasanjo revoked the license. And that marked the beginning of the series of controversies and tussles that gave birth to the OPL 245 saga, tagged by sections of the media as a Malibu scandal. There are 1,001 questions over the saga. What actually went down? Why did President Obasanjo revoke OPL 245 in 2001? Why did President Goodluck Jonathan return the oil block to Malibu in 2010? What was the interest of the Abacha family in OPL 245? What was the interest of President Muhammadu Buhari, whose government filed criminal charges against the principal actors? How did Mohammed Bello Adoke become the central figure in the court cases? And most importantly, why did Nigeria lose all the major OPL 245 court cases in Italy, the UK, and Nigeria? Questions, questions, questions. Now what you're about to hear is the inside story of the OPL 245 affair the way you have never heard it before. The story has been told in bits and pieces, but now we tell you in authoritative detail. My name is Kayode Okikiolu, gentleman of the press, and this is a Malabugate story. So let's start from the very beginning, shall we? You see, Nigeria discovered oil in commercial quantities in 1956 when Shell BP, as it was then known, hit the black gold in Oloibiri in the Niger Delta. Well, Oloibiri is located in present-day Bayelsa State. And in 1958, Shell BP began production and export. Now, there was no huge revenue for Nigeria until 1973, when the Arab-Israeli war led to a spike in oil prices. So oil-producing countries experienced their very first major oil boom, and the world has never remained the same again. Now, that was the beginning of Nigeria's stupendous oil wealth. However, despite the strategic nature of oil to the economy and politics of Nigeria, well, exploration was being done by only foreign companies. Well, the National Oil Company, which is now known as the Nigerian National Petroleum Company Limited, only exists to manage Nigeria's interest in the production ventures. So, between 1985 and 1993, General Ibrahim Babangida, who was a military president at that time, then decided to get indigenous companies fully involved in the oil industry. He introduced the Indigenous Exploration Program in 1993 to sort of incentivize Nigerian companies to participate in oil exploration and production. Now, one of the incentives was to lower the entry barrier through a concessionary signature bonus of $20 million. So local companies were also granted a special dispensation to engage oil majors' technical partners. So early beneficiaries included Oriental Energy Resources Limited, owned by Alhaji Mohammed Ndimi, Consolidated Oil Limited, owned by Dr. Mike Adinuga, and Famfa Oil Limited, owned by Mrs. Folorisho Alakija. But the government of General Sani Abacha, who became head of state in November 1993, awarded several prospecting licenses in 1998. OPL 246 was awarded to the South Atlantic Petroleum Sapetro in February 1998. Well, Sapetro, by the way, is owned by General T.Y. Danjuma, former Chief of Army Staff and an associate of General Sani Abacha. OPL 245, on the other hand, was awarded to a company known as Malibu Oil and Gas Limited. But then, General Abacha died suddenly on June the 8th, 1998. Before we delve into the intriguing story of Block 245, here are some quick facts.
The oil block is 150 kilometers off the coast of the Niger Delta and 1,000 meters below sea level. By 2006, about 1 billion barrels of oil equivalent had been discovered in Etan and Zaba fields in the block. In 2011, Open Economics, the Italy-based economic think tank, projected that Block 245 would cumulatively increase Nigeria's GDP by $41 billion and generate $3.9 billion in tax revenues to the Federation over the 25-year lifespan of the project. In 2018, Resources for Development Consulting, a Canadian think tank, projected revenues of between $9.8 billion and $15.6 billion to the Federation under different scenarios over the project lifespan. The block would add at least 150,000 barrels per day to Nigeria's output when production starts fully.
Therefore, by every measure, Block 245 is not a little asset.
You see, when President Obasanjo came to power in May 1999, he revoked many OPLs awarded by General Abacha, but he did not touch OPL 245 and OPL 246. Well, the same month, Chief Dan Etete, former Minister of Petroleum Resources, came out as a consultant and a public face of Malabu, the allottee of Block 245. And Malabu made a down payment of $2.04 million out of a $20 million signature bonus, and this left a balance of $17.96 million. On March 9, 2001, Mr. Macaulay Ofure, the director of the Department of Petroleum Resources, then DPR, but now NUPRC, the oil industry regulator, wrote to Malabu, giving the company the go-ahead to develop the block. Thereafter, Malabu approached Shell Nigeria Exploration and Production Company Limited (SNEPCO), which is a subsidiary of Royal Dutch Shell, to propose a joint development under what is called farming agreement. Now, under a farming agreement, SNEPCO, as a technical partner, was to take 40% stake in the block, while Malabu will retain 60%. So SNEPCO was to pay $17.96 million. You remember the balance of the signature bonus and bear the costs of exploration and development. But that's not all. It was also to bear the costs of Malabu's obligations. It would amount essentially to SNEPCO giving a loan to Malabu to pay for its own share of the costs. But Malabu will then repay the loan from its share of oil production. But then SNEPCO initially was reluctant to take up the offer, but then it said it did after receiving some written representations from Malabu's registered shareholders that they, get this, were the only two shareholders and that Etete and Mr. Mohammed Abacha had no interest in Malabu. SNEPCO also said it obtained assurance from the Nigerian government that it had no intention to revoke the block from Malabu. Now on March the 29th, 2001, SNEPCO assigned its rights and obligations under the farming agreement to Shell Nigeria Ultra Deep Limited, which is its sister company, with the consent of Malabu, of course. Now, on March the 30th, 2001, Malabu and Shell Ultra Deep executed the agreement, but Shell Ultra Deep took the 40% stake and became the operator of the block under a JOA, as a Joint Operation Agreement. Fast forward to April the 6th, 2001, where Shell Ultra Deep issued a check of $17.96 billion to the federal government for the balance of a signature bonus, although it was not cashed, as Nigeria presented a check at Citibank, New York, instead of Citibank, Nigeria. Well, I need to grab a seat for this one. You see, with the regulatory approval of the Joint Operation Agreement, the Ministry of Petroleum Resources issued Malabu with the Oil Prospecting License number 245. It was dated May the 15th, 2001 and effective from April the 29th, 1998, which is the original date of award. The title deed was then forwarded to Malabu via a letter dated May the 24th, 2001. And all was well, or so everyone thought. Suddenly, on July the 2nd, 2001, the Obasanjo administration announced the revocation of OPL 245 from Malabu. Now that was a major twist in the tale. In its letter to Malabu, the DPR simply said the allocation had been withdrawn and the title deed revoked. Etete would later allege that Obasanjo wanted to take over the block and that his resistance led to the summary revocation. Obasanjo denied and threatened to sue him for defamation, but did not follow through. In April 2001, Shell Ultra Deep and ExxonMobil were invited by the federal government to compete for the block as production contractors to the NNPC, which owned the block. So Shell Ultra Deep, which was Malibu's technical partner before the revocation, was thereafter awarded OPL 245 by the federal government in May 2002. Shell Ultra Deep was asked to pay a new signature bonus of $210 million since it was no longer a concession under that indigenous exploration program. Yes. When Shell Ultra Deep was awarded OPL 245 in May 2002, it commenced International Chamber of Commerce arbitration proceedings against Malibu, apparently to protect itself over the new state of affairs. So in August 2002, Malibu also commenced proceedings in a New York federal court against the Nigerian government, SNEPCO, Shell Ultra Deep, and other Shell entities. So Malibu also petitioned the Nigerian House of Representatives over the revocation. And in May 2003, the House of Representatives issued its findings in favor of Malibu, concluding that OPL 245 was legally awarded to Malibu and that the revocation should be set aside. But that's not all. Also, it recommended that Shell Ultra Deep pay $550 million compensation to Malibu. Well, President Obasanjo did not act on that report, and in September 2003, Malibu filed a case in a Nigerian court against the federal government, NNPC, and Shell Ultra Deep, seeking a reinstatement of OPL 245 and an award of $100 million in damages. But fast forward to November 2004, the International Chamber of Commerce panel ruled in favor of Shell, describing as lawful the actions of the Nigerian government in revoking that license. But the ICC also declared that Shell was not to blame for the revocation, and the company was right to participate in the bidding process after that revocation. Well, in December 2003, Shell Ultra Deep paid $1 million of a signature bonus and deposited the balance of $209 million in an escrow account at the JP Morgan Bank in London because of the dispute, of course. Well, the escrow account was operated jointly by the oil company and the federal government of Nigeria, and that's pending the resolution of all the disputes. Well, NNPC then entered into a production sharing contract, a PSC, with Shell Ultra Deep for the development of OPL 245. And while all legal tussles were going on, Shell Ultra Deep began oil prospecting. And on March the 16th, 2006, Malibu's case at the Federal High Court was struck out based on the Public Officers Protection Act. But the court ruled that Malibu filed its action out of time. But Malibu was dissatisfied and it lodged an appeal. You see, while Malibu's appeal was pending in court, something interesting happened. Take a look at this. The federal government's lawyers, Babalaki and Co., wrote to Mr. Bayojo, the Attorney General of the Federation, to raise a point of law, warning that the federal government might lose a case and it will be costly. Well, on receiving the letter, Ojo wrote to Dr. Edmond Dalcoru, who was a Minister of State for Petroleum Resources, asking for an out-of-court settlement, of course based on Babalaki and Co.'s advice. And on October the 3rd, 2006, Dalcoru wrote to President Obasanjo to inform him of the proposed out-of-court settlement and to seek his approval to proceed with it.
Dalcoru wrote, "In the light of the above, Mr. President is respectfully invited to approve the proposal for out-of-court settlement of the suit brought by Malibu in respect of OPL 245 as outlined."
And President Obasanjo wrote, "Minister of State, approved." On November the 30th, 2006, the settlement agreement was signed by the federal government and Malibu. It was then registered as a consent judgment of the Federal High Court. The terms of the settlement agreement were that the federal government would reallocate Block 245 to Malibu in the spirit of amicable settlement and without any admission of liability for any alleged wrongful, unlawful, unjust, or any like conduct. That the new signature bonus shall be $210 million. But since Malibu had earlier paid $2,040,000, the balance will be $207,960,000 payable within 12 months after the execution of the agreement. that Malibu could assign Block 245 or any part of it in accordance with the provisions of the Petroleum Act, that Malibu shall not raise any issues or bring any court action again regarding losses, liabilities or damages over the revocation of Block 245. That Malibu shall terminate its case at the Court of Appeal after the execution of the settlement agreement. On December 2, 2006, Dalkoro wrote to Etete to confirm that the settlement agreement had been approved by Obasanjo. Dalkoro also informed Shell Ultra Deep that as part of the settlement, the oil company will be awarded another block with comparable potential and hydrocarbon prospectivity. And following this, Malibu discontinued its case at the Court of Appeal on January 16, 2007. But that's not all. You see, years later, then President Obasanjo would deny approving that agreement. And the settlement agreement was just another lap in the long-distance race. Shell Ultra Deep was predictably injured. By the turn of events, it had a good claim on the federal government because it had been assured that all was well before it went ahead to de-risk its investment in the block. And now, OPL 245 was gone again. Its next step? Shell said it held a meeting with Obasanjo in February 2007, where it was agreed that Malibu should be given a share of NNPC's 60% stake in the block. Malibu rejected the offer, insisting on the implementation of the settlement agreement. In April 2007, Shell Ultra Deep filed a notice of arbitration against Nigeria at the International Center for the Settlement of Investment Disputes, an organ of the World Bank. It demanded a compensation of $1.8 billion, alleging expropriation of its estimated investment of $500 million. In his last days in office, Obasanjo wrote to Dalkoro, seeking to clarify his position. He said Shell Ultra Deep should remain the contractor, having de-risked the block, while Malibu and NNPC will be the concessionaires as co-owners. And when President Umar Musa Yar'Adua, when he assumed office in May 2007, the OPL 245 saga was one of the issues he inherited from the Obasanjo administration. So in August 2007, Yar'Adua set up an interministerial committee to resolve the dispute in a way that would accommodate the interests of both Malibu and Shell Ultra Deep. Now, part of the proposal was to compensate Shell with an oil block with equivalent of 50% of Block 245, but Shell rejected the offer. And in comes Dr. Goodluck Jonathan, who became president after the death of Yar'Adua. But it was barely a week in office when on May 11, 2010, Malibu wrote a letter to him asking the new administration to implement the 2006 settlement agreement, which was entered into by the Obasanjo administration. Well, the letter was signed by Mr. Raski Benige, who's Malibu's company secretary and legal advisor. So what did Jonathan do? Well, he asked Mr. Mohammed Bello Adoke, the Attorney General, for legal opinion on the settlement agreement. And in his response, Adoke said he had reviewed all the relevant documents, and his opinion was that the 2006 agreement was subsisting and enforceable. So Jonathan decided to implement the 2006 settlement agreement. This was communicated to Malibu by Mrs. Dezani Alison Madueke, Minister of Petroleum Resources, via letter dated July 2, 2010, ironically on the 9th anniversary of the Block 245 revocation. Still, this did not resolve the problem, as Malibu and Shell still bore historical grudges against each other. In fact, Shell had an outstanding arbitration award of $20 million against Malibu, and had also launched an arbitration proceedings against the Nigerian government over the 2006 settlement agreement. That should have been the end of the story, right? But no, this story is far from over, because after the return of OPL 245 to Malibu, Malibu engaged the services of middlemen to market the block, indicating that it was ready to sell off its entire interest. Mr. Adnan Agaev, a former Russian intelligence officer, had introduced Mr. Emeka Obi a Nigerian businessman, to Malibu in December 2009 to help it find buyers. And that's even before the block was returned to the government. Eni, an Italian company, indicated interest in acquiring the block. But Shell was still interested as well, having invested hundreds of millions of dollars in developing the acreage. Malibu was no longer interested in doing business with Shell because of the bitter history between them, and Eni could not go ahead with its interest because of Shell's position. Deadlock. So the parties approached the federal government, asking it to broker a resolution of the crisis of confidence. Shell and Eni offered to acquire Malibu's 100% in Block 245, and after a series of negotiations and meetings by all the parties, a number of resolutions were reached. 1. Malibu and Shell Ultra Deep agreed to terminate all the court and arbitration proceedings regarding OPL 245. 2. Malibu agreed to relinquish its entire interest in OPL 245 for a compensation of $1.092 billion. 3. Federal government agreed to indemnify Shell and Eni against future claims on the oil block. And 4. Shell and Eni agreed to pay the agreed price of $1.092 billion to the Nigerian account at JP Morgan in London, in addition to the $210 million signature bonus. In all, the payments came to $1.3 billion. But let's backtrack a bit. Now recall that in December 2003, Shell Ultra Deep had paid $1 million of the signature bonus and deposited the balance of $209 million in an escrow account at JP Morgan Bank, and that was pending the resolution of the dispute. As disclosed later, contributions from Shell entities amounted to just under $320 million, including the release of the signature bonus from the escrow account. Now, Eni contributed the remainder $980 million. But there's one more detail. Before the Block 245 resolution agreements were signed, Mr. Andrew Obaje, who was the then director of the Department of Petroleum Resources, raised an objection over the non-provision for a back-in right for Nigeria. Now, what is a back-in right? Well, a back-in right would allow the country to take a share in the oil block in the future. A committee was set up to look into Mr. Obaje's objection, and the back-in right provision was inserted. So on April 29, 2011, Malibu, Shell, Eni, and the federal government of Nigeria signed the suite of agreements known as Block 245 Resolution Agreements. So it appeared the whole controversy had finally ended. But another phase started after the execution of the resolution agreements. And so, the federal government instructed JP Morgan to transfer Malibu's $1.1 billion to the account of Petrol Services Company Limited with BML. That's a bank in Lebanon. Now, that was the account provided by Malibu. On May 25, 2011, JP Morgan tried to transfer the money, but the Lebanese bank rejected the transfer. And that was the first red flag. On June 15, 2011, Malibu wrote to the Nigerian Minister of State for Finance, Dr. Yerima Lawan Ngama, to inform him of a development. And Malibu then provided its Nigerian bank accounts, which Ngama then communicated to JP Morgan. But another problem was brewing. In July 2011, it emerged that Malibu was having a running battle with its own partners, who said they were middlemen and consultants in the OPL 245 transaction, and they wanted their payment. Emeka Obi's company, Energy Ventures Partners EVP Limited, had on July 18, 2011 secured an ex parte order from a UK court, freezing $200 million of Malibu's money. He alleged that there was a verbal agreement to pay him that amount as finder's fee. He also asked the court to award $15 million to him as cost. JP Morgan was served that freezing order. A second company, International Legal Consulting Limited, a Swiss entity owned by Agaev, then sued Malibu for $65 million in the US. Agaev, Obi's friend, claimed he was entitled to 6% of the payment to Malibu. The bank got in touch with the Nigerian government over the court order. Officials of the Finance Ministry referred the letter to Adoke, the Attorney General, and asked for his legal advice. In his response dated July the 8th, 2011, Adoke advised the ministry that a court order should be obeyed regarding the sums to be frozen and the unencumbered amount could be transferred to Malabu's nominated account. Well, officials of the Ministry of Finance thereafter instructed JP Morgan to transfer a total of $875 million to Malabu's bank accounts in Nigeria and to withhold the balance pending the outcome of the court proceedings. But JP Morgan also sought and got the approval of the UK Serious Organised Crime Office before transferring $401,540,000 to Malabu's account with First Bank of Nigeria PLC and $400 million to its account with Keystone Bank. Well, that happened on August 23rd, 2011. The balance of $290 million was withheld by JP Morgan, but the court cases eventually went in Malabu's favor. You see, telling the OPL story is definitely taking its toll, hence the need for some room to stretch. Because with the OPL 245, nothing is ever done and dusted. At every turn, there is always a new controversy. And what happens next turned global attention to OPL 245 and led to what anti-corruption campaigners called the world's biggest corporate fraud trial. A coalition of international NGOs had started raising issues after Block 245 resolution agreements were signed in April 2011. They alleged money laundering and international corruption. They were particularly alarmed at the involvement of Etete, especially as he had been convicted of money laundering in France in 2007. It said Malabu was engaged in criminality, reporting that it was registered using a fictitious character and that it maintained a fake address with the Corporate Affairs Commission. And this marks the birth of the Malabu scandal in media reportage. They alleged as follows: that OPL 245 was unlawfully acquired by Etete when he was a Minister of Petroleum Resources, and that his interest in OPL 245 was held through Malabu. That Eni negotiated and participated in a corrupt agreement that enabled Etete to crystallize and launder these illegally obtained assets through a convoluted deal that resulted in a consortium of Eni and Shell acquiring OPL 245 through the resolution agreement of April 2011. That's the belief that both Etete and the son of General Abacha were shareholders when the oil block was awarded raised the concern that the award of OPL 245 was a way for Nigeria's ruling elite to profit illicitly from the country's natural resources. There's a long list. The next one is that after the death of Abacha, Etete reportedly increased his shareholding in Malabu fraudulently, taking control of 100% of the company, and that Mohamed Abacha had petitioned the EFCC to investigate the matter in January 2012. Well, the Corner House and Global Witness also petitioned the Metropolitan Police Service in London to look into the OPL 245 transaction. The international NGO's partners in Nigeria were Header Resource Center and Premium Times. So in September 2013, Recommon, the Corner House, and Global Witness made a significant headway when they sent a similar petition to the Public Prosecutor's Office in Milan, Italy. Don't forget that Eni is an Italian company. So on December the 20th, 2017, the Court of Milan issued a decree ordering the indictment of 15 individuals and entities, including Shell, Eni, Etete, and some former employees of the oil companies. They were ordered to appear before the 10th Division of the Court of Milan at the commencement of the hearing, scheduled for March the 5th, 2018. When Nigeria joined the lawsuit as the injured civil party, the prosecutors filed separate charges against Mr. Emeka Obi, the CEO of Energy Venture Partners, and Alhaji Aliyu Abubakar, who's a Nigerian property developer, accused of being the conduit through which bribes were shared to government officials. The same month, Nigeria filed a civil suit against JP Morgan in a UK court seeking a $1.7 billion compensation from the bank for transferring $875 million to Malabu in 2011. Now see what happened. Nigeria invoked the Queen's Care Duty Doctrine, arguing that JP Morgan should have known that the money transferred to Malibu was part of a fraudulent scheme. But in Nigeria, the EFCC filed court cases against Adoke, Aliyu, Binige, Malibu, Ajib, same as Eni, Shell Nigeria Exploration, and Shell Ultra Deep, a long list, alleging corruption, money laundering, and conspiracy to commit forgery. So, Malibu scandal started to feature prominently in the Nigerian media coverage of the court proceedings. It was a private company on whose behalf the Attorney General of the Federation could not act. He advised that the directors should hold a meeting to resolve the issue, otherwise they should approach a court of law for judicial intervention. So on December the 18th, 2012, Abacha wrote to Adoke to inform him that he had nominated 2 lawyers to represent him at the dispute resolution meetings with other Malibu shareholders. But the Nigerian House of Representatives is also said to have looked into the dispute. Well, the OPL 245 story never really comes to an end, does it? Because on October the 8th, 2024, an Italian court jailed the prosecutors for hiding vital evidence during the trial of Shell and 14 other defendants by the Court of Milan. Fabio De Pascal and Sergio Spadaro were the 2 prosecutors who were sentenced to 8 months in prison by Brescia Court for not disclosing documents that could have vindicated the defendants. Adoke, though not on trial in Italy, had earlier written to complain to the Court of Milan that the prosecutors were hiding evidence that showed that the Abuja property linked to him, which was described as a bribe from the OPL 245 deal, actually belongs to the Central Bank of Nigeria. Adoke also complained to the Nigerian police that an email was forged and an interview with an imposter was stage-managed to implicate him in the court cases. Well, the police investigated and charged Mr. Olariwaju Suraju, the frontline Nigerian anti-corruption campaigner and chairman of Header Resource Center, to court for allegedly circulating the materials on social media. Header was, by the way, the Nigerian partner of the international NGOs that brought the Malibu case to global attention. You remember? Well, the court cases against Suraju was eventually terminated by the government before the trial could start. For now, can we conclude that the long-running OPL 245 soap opera, which started unnoticed in 1998 and went on to acquire global fame, has ended?
We love our food, parties, and the good time. But how do we feel afterwards? However these 7 symptoms of heartburn and indigestion feel like to you, all 7 symptoms are caused by stomach acid. So Gaviscon Double Action acts in your stomach to neutralize acid fast and forms a raft to prevent content from going back up the food pipe. For long-lasting relief, for any of these 7 symptoms, think Gaviscon.
Baba legun baba wa ojo tí ojo mọ́ kò jó mọ́ náà.
Adéyìnfẹ́. Ṣé wọ́n ló ṣe?
Ṣé kí ni?
Kógun já àwọn èèyàn mi. Sọ dọ́gbọ́n fún mi ni.
A thriving city is a place where food is accessible, affordable and available. You grab, you go. Unfortunately, the current system of food has not benefited the stakeholders. There's been excessive waste, leading to high carbon emission, energy waste and high price. This is the situation all over Nigeria and across Africa. However, Lagos has chosen to make the change. Lagos is working hard with various stakeholders and neighboring states with a current growing population of over 24 million people. The United Nations projects that Lagos population could rise to about 36 million by 2050. Hence, the capacity to feed this fast-growing population has to be scaled. An organized market enable organized production.
Now is the time to reorganize.
With cases of climate change, desertification, and increasing prices.
Now is the time to reorganize.
With high rural-urban migration and the need to maximize resources.
Now is the time to reorganize our food systems.
The LHP Hub MLM market grain transit jetty and production hubs will greatly benefit farmers by increasing their income and also guarantee off-takers. It will reduce prices of food and make it readily accessible, benefiting all the stakeholders within the value chain, including the government, by way of additional revenue. For more inquiries, please contact the developer, Origin Tech Group, at www.origingroupng.com or the Lagos State Ministry of Agriculture and Food Systems.